Only notice में क्या है?
My lord, this is also fresh contempt.
Just take one question.
My lord.
When the order was made, what was the time line given?
10/10/2025, 8 time was given, my lord.
They have not done anything.
No, my lord, not anything.
Yes. Item numbers 1 to 73. Any other matter where compliance is reportable?
My lord, item 5. Item 5, they have rejected in the meantime. Your lordship was pleased to direct to consider the case in case of in the IT of Loknath Behera.
Now they have rejected.
Rejected on the ground that Loknath Behera came.
Is it rejected?
Yes, fine.
Then you have to challenge it.
That's why your lordship may dispose of the matter.
Fine.
Yes, madam.
This complaint alleges non-compliance of the order dated 27/11/2025 entered in complainant WPC number 33066 of 2025. After issuance of contempt notice,
No notice was issued. In the
now you have got it. First time it has come.
Yes.
At the stage of admission of the matter, learned counsel appearing for the complainant, he clearly submits that the subject representation of the claim has been negatived
By order dated 2/2/2026.
by the order number 5543 dated 2/2/2026, and therefore the proceedings be disposed of, preserving liberty to the complainant to take up appropriate action for challenging the said order. First off, I agree. First off, ordered accordingly and proceedings ordered.
Item 61, my lord. Item 61.
5 is over 1 to 73.
My lord, item 61.
Other advocates may go in all those cases. I am issuing no police notice. Wherever there is compliance by way of rejection or otherwise, those lawyers are requested to be here to assist.
Item 61.
Item 61, 6.
1 second. Now 5 is over, na?
Yes.
16.
61.
61.
61.
It has become infectious.
No, my lord. My lord, it is arising out of the interim order. There has been a mistake on my part. The incumbent mentioned as contempt number 1 has been wrongly mentioned. I have filed an IA that has not come on record.
It has not come now. Give it again.
The IA number is 423 of 2026, my lord.
In 61. Complainant has moved an application in IN number 423 of 2026 supported by affidavit seeking leave of the court to effect certain changes which have occurred in paid advertently. First, the matter is at the admission stage and no prejudice should be caused to anyone should this application be favored. First, in the above circumstances, application is favored and leave is accorded to effect the rectification as sought for.
Consolidated cost settlement index has also been filed.
First, learned counsel for the appellant submits that already amended cost table and index have been filed. First, in view of the above, issue police notice to the parties shown in the corrected cost table. Fixing which date you are fixing? 7th August for reporting compliance. Format, it should go in the format.
Item 20. Item
20.
Partly compliant.
Partly compliant.
Yes,
Rest of the things you challenge. What can be done? Critical exam.
Directed for regular posting, they gave regular posting, but paying only 5,000 rupees consul.
Separate. Serial number?
20 blocks.
Serial number 20. This complaint alleges non-compliance of the order dated 8/8/2025 entered in complainant's WPC number 1143 of 2024. First, at the stage of admission, the counsel appearing for the complainant very fairly submits that there is a substantial compliance of the said order, while the endorsement dated by the endorsements, where is that? Compliance, full stop. He even more fairly submits that the proceedings be dropped, reserving liberty to the plaintiff to lay a challenge to the non-compliance of rest of the order, keeping open all contentions of the parties. First of all, I agree. Ordered accordingly, proceedings are dropped.
Item
Yes.
31.
Look, can I let it lots of continue?
Why? No.
Because again, look, since
20 is what?
31. 16.
16.
Implemented.
Implemented. Serial number?
16, my.
This complaint arises out of allegations of non-compliance of the judgment dated 17/12/2025, handed the complainant's WPC number. Which is your number? There are many numbers. Which is your number?
32343.
32343 of 2025. First of all, next paragraph. At the stage of admission, learned counsel representing the complainant submits, and this court appreciates the same, that there is a compliance of the order whose violation is alleged, and therefore proceedings be dropped. First of all, next paragraph. I agree. Ordered accordingly, so it's a fine. So if there is any grievance left, it is open to the complainant to take appropriate proceedings in that connection. And all contention for that are kept open. Yes.
Item 30 million complied million.
30.
Yes, bro.
At the stage of admission, learned counsel appearing for the complainant very fairly and at the outset submits that the proceedings be dropped in view of compliance of the order dated 18/11/2025, handed in his client's WPC number 20803 of 2024. First off, I agree. Proceedings are concerned.
31 lordship. 31.
21.
31 lordship.
31.
31 lordship they have rejected.
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 Lay a challenge to this.
Yes.
The complaint, this complaint alleges violation, non-compliance of the order dated 10/12/2025, entered in complainant's WPC number 32282 of 2025. First, at the stage of admission, learned counsel appearing for the complainant very fairly submits that the representation of his client having been considered has been rejected while order dated
7/7/2026.
7/7/2025.
26.
26. 7/7/2026, and therefore these proceedings be dropped with liberty to lay a challenge to the said rejection elsewhere in accordance with law, keeping open all contentions of the party. First of all, I agree. Yes, next in view of that, so it's a fine spot.
Item 74, contempt High Court 99/2025.
Drop time IF for revival because audit has not yet been accomplished, madam.
You have sought for revival.
Yes, madam. The Lordship is the order dated 13/2/26. Order number 2 in the contract petition.
Matter is still pending.
Audit has not in the direction was meant to accomplish the audit within 2 months. It is not yet accomplished, madam.
Mr. G, what do you say?
My lord, a compliance affidavit was filed earlier. There they said that audit was made and audit was made properly.
Show that. Prima facie.
Prima facie, my lord, lordship may kindly have a look to the compliance affidavit which was filed on 2/7/2026.
Yeah, Mr.
Lord, I am leading the court. And AJ, on being drawn his inadvertence to the subject letter dated so and fairly submits that audit can be accomplished in a normative way, and there shall be a cooperation from all the stakeholders, including opposite party number 4, who is presently in charge of the post of official principal. 9. It was filed on 2/7/2026.
7/26.
Yes.
They have done that. This complaint you have filed when? After 2/7?
In April 26.
Yes, now they have 2/7, they have given
I have,
reporting
I
compliance.
have got it, my lord.
Ah.
It is not compliance, my lord. They are showing an audit of February 2006. They are showing an audit of February 2006, my lord. I have got it, my lord. It is, your lordship should page 6 of that compliance report, my lord.
6.
Page 6.
You take chance before the other judge.
They are showing an audit of 2006, my lord.
There is.
Yeah, whatever you want to do to that application. If you want to file objections, you file objection.
Yes, yes.
This application seeks a revival of content proceedings that will drop pursuant to order dated, wait, order dated?
13/2, my lord.
13 February 2026. First up, learned counsel appearing for the applicant submits. There is a non-compliance of the order in question in substance and content, and therefore proceedings be reopened. First up, Mr. G appearing for the contender seeks a short accommodation to come out with his objections. First up, call on. Next.
Item 75, content 6/8/2025.
Yes, sir.
My lord, they have, your lordship directed to give all the financial benefit from the date of entry into the service.
Have they given you?
No, they have not given. They have given from 2022, not to
Not from
20. Lordship,
yes, see,
this,
you have to give particular date is mentioned. With effect from that date, you ought to have given.
My lord, your lordship.
Again, one more fighting, one more legal battle.
Another IA he has filed.
That's what. You have
My
signed
lord.
6 revival.
Yes, revival of the contents.
Yes, you file objection to that.
I'll file
compliance.
Yes.
Application seeks a revival of the contempt proceedings that were dropped by the order dated so and so. Take out that 21/8/2025. No, were ordered in contempt matter. 8/5/26. When the contempt proceedings were dropped?
11/5.
11/5/2026.
11/5/2026. First of all, learned counsel appearing for the complainant points out that a particular date was fixed by this court at the writ side, with effect from which the arrears ought to have been computed and paid, and that has not been done. Although some payment is made, taking other date posterior. First term, matter requires deeper examination. First term. The next paragraph, on the request of the AG appearing for the contemptants, a short accommodation is granted to come out with his version to meet the application. Column. Next.
Item 76.
So only I pray that date of joining that is 1/2/20.
That they will look into. Yes.
76.
Same also. This one same they have given from 22 only.
Same order.
Same order.
77.
Only I pray your lordship to date of entry into the service.
No, that you have said, we have written already.
Yes.
Yeah. Same order. Next.
7.
77 also not from the date of entry into the service.
Same, all three will
all the
Yes, all that. All those
Same.
5 lords.
78.
Same.
Same.
Next.
Item 79, content 8/3/2026.
May I please?
Yes, sir.
Your lordship may see the page 7 of the IA, my lords. After service of notice, the contemptor have entered appearance through the land AGA, Mr. Mohanty, who submits that there is a substantial compliance of the writ, and all necessary papers have been submitted to the Office of the Controller of Accounts. As yet, my lords, nothing has been done, my lords. No
Nothing has been
compliance.
done.
No,
So revival.
my lords. 2007.
Application in I number so for seeking supported seeks revival of the content proceedings that were dropped by the order dated. First term. Next level. Counsel for the applicant submits that the proceedings were dropped accepting the submission of the contempt submission made on behalf of the contemptors, which is not true and correct, and therefore there is an aggravated contempt. First term. Matter requires deeper examination. In the circumstances, at the request of learned AG appearing from the contemner, a period of 10 days will be granted to come out with the version of the claims. Column.
Item 80, content 1724.
But also they have not complied, but it is order dated 15/5/26.
The proceedings were dropped by order dated 15/5/2026, accepting prima facie compliance of the order dated 28/11/2025, entered in complainant's WPC number 1908 of 2025. First means, learned counsel for the applicant now finds out that there is no substantial compliance, and therefore the dropped proceedings are liable to be reopened. First matter requires deeper examination. Last one, he requires necessary.
Only I pray date of entry, nothing.
That we cannot do this. Let him come out on their version. That can be
The
done.
content application, it cannot be.
Yes. What?
matter. Well, what is committed, a petition was filed
Sir, this is
for consideration before the.
This is item 1.
Item one. Health officers.
Upavakta Mahila.
My lord,
But the
Gopinath Mishra.
my lord, myself.
petition was not considered. So it was filed. When
Kindly take us to the operative portion of the order. Kindly take us to the operative portion of the order.
Page 11, paragraph. Page 11, paragraph 3.
Which but not one is directed to consider state representation considered. Dated 11 September 2023, Mr. Mohanty submits the representation is in context of request for proposal dated 21st November 18 already issued. Petitioner will communicate certified copy of this order to set of party.
Will issue notice now.
That is good.
Submit the council appeal for the council on record for the complaint. First of all, a prima facie case is made out for issuance of emergent police notice. First of all, issue emergent notice. Police call on site.
My lord, Mr. Guru Prasad Mohanty.
Yes, Guru Prasad. Yes. You appear for the wife? Yes.
My lord, I am appearing for the husband, my lord. My lord,
Police notice is served.
no, my lord, your lordship directed to next date will.
Arrest and detention we
My
ordered.
lord, today, my lord, the brother of the husband. No, my lord.
What is this?
My lord, the brother of the husband filed a check, my lord, original.
Brother, sir, very difficult.
I undertake, my lord. My lord.
I forgot your name.
Yes. Panda, my lord. My lord. My lord. Yes, yes.
If somebody other than judgment debtor,
Yes.
can the court entertain anyone?
That is why, my lord,
Advise your client to receive
Yes.
that from his brother?
My lord, I undertake, my lord.
No,
by
undertaking, but you are not listening, that's the problem.
Yes, sorry, my lord. Sorry, my lord.
Understand.
Sorry, my lord.
If you are inviting any other than a judgment debtor to satisfy the decree,
My lord.
there is no concept here in CPC.
Yes, my lord.
To my little learning, what
My
I
lord, my
understand.
lord, my lord.
So you ask your client to take that money from brother and deposit it.
My lord, that is why I am praying, my lord. On 21st, I will deposit the demand draft. By way of security undertaking, I submit this check, my lord. On 21st, I will demand.
Arrest and detention.
No, there is need. There is eminent need for arrest. and
Because of
detention.
he
Because the message
he is
to
not in
go-
station. That is why I pray on 21st.
No.
I will deposit the bank draft.
Let him be
Both
till
the
21st.
brothers have sat on the High Court judgment 6 years.
My lord, so I oblige your lordship. I have no defense to that.
Then we will arrest him.
My lord, kindly appreciate. My lord, only one.
I'm going to the wife.
My lord, on 17, my lord.
No.
I deposit the demand draft.
Shubhasya Shigram. Arrest and detention is a Shubhalakshana in the court. We are not here to conduct
Only
the
1
case.
day to deposit the demand draft.
No.
Only 1 day.
No,
19.
no, sir. It should appear in all newspapers. Otherwise, everybody will take. Today, are you going to deposit?
Today, my lord, I will prepare the demand draft.
Huh?
Preparations are deposit.
Deposit, my lord.
But I am not receiving it.
Deposit comes, sir. You should hand it. Not question of deposit.
By tomorrow, my lord.
No.
By 5 p.m. 5 p.m. my lord, 4 p.m. because of my
Where is
flight.
your client?
Jajpur, my lord.
Jajpur.
Yes.
Jajpur comes under which superintendent of police? Jajpur.
My lord, I will deposit by 4. By 4, my
Order
lord.
dated 6/7/2026. We had
My
said
lord,
as
today,
a
my lord, I will deposit, my lord.
first off. Here is an unkind husband who does not show any respect to the court order. That is made on 17/8/2023 in Mata number 132 of 2023. First off, law and scriptures injunct husband to look after the wife. First off, that has not happened in this case. Despite a mandatory court order, which is in simple English. First off, added The accused and his counsel were absent on 24 sent on 7/7/2020. No, 7/2026. Because we told them to call on next day.
You said they are not approved. So 27/11/2025, they started.
The same thing happened on the earlier occasion, that is 27/11/2025. First up, the right place for such people is the prison and not the civil society. First up, anything short of that would shake the confidence of sensible people, sensible section of the public, which court should not allow to happen. First up, in the above circumstances, the superintendent of police Judgepur is hereby ordered to arrest the respondent.
Polite melod in course of a day melod. I will do.
No.
In course of a day melod,
We have
kindly
taken oath to do justice.
melod kindly
People.
allow some time melod in course of a day melod.
No, don't print that order. If he does not bring the money, print that order.
What we can do, get the bank account and deposit
Get the bank account.
Yes, your lord. Yes, sir.
or
Credit that
or
money.
you may get
Yes, your lord.
Monty. Monty,
Monty, you
Make
tell,
it okay.
you call your police superintendent. Tell him, keep his force ready for arresting before the sunset.
Melod. In course of a day, I will, yes, your lord.
Please do not play with the court. This court is disappointing the public in contempt matters,
Yes.
I tell you. I have seen this court
Yes.
for 1 year, 2 months. Where is the respect for the court orders? No respect for the court order. That is not the way that we are not here to please anybody. We are here to levy a deep cut those who do not answer the court's
so
requirement.
Panda, after retirement of honorable judge,
Yes,
it
sir.
becomes difficult to reach the matter.
Yes, your lord.
It comes-
No.
Melody in course of a day, I deposit in her account and I inform your lordship. Only.
To find the method.
Now,
Yes, your lord.
now we have passed this in learned counsel at this stage submits that the entire amount due shall be credited to the bank account of the complainant wife before 4 p.m. this day.
Yes, your lord.
First up. Therefore, this order shall not be implemented till 4 p.m. 4 p.m. All right? You sign it and send it to the 3 p.m. before 3 p.m. All right?
Oblige, your lord.
What cost you will be paying? This is like thief giving the article back. That will not suffice.
Oblige.
She has suffered.
Yes, sir.
How she has held her soul and body together without any support from a cruel husband like your client. So he has to give another 1 lakh rupees. 1 more lakh.
My lord.
Call this matter for reporting compliance tomorrow and for deciding what should be the penal cost payable by the respondent husband. Call tomorrow. We have made this order. Now we are calling it. Okay. Send this copy to the superintendent of police. Mr. The registry shall share a carbon copy of this order with the learned AGA, Mr. Mohanty, for securing due implementation of it. Call tomorrow.
recovery by the employees have to allowed to continue for they are not complying. Therefore,
23rd.
pension matter my Snodandra Mali.
May I please your
Place content.
May I please your lordship, my lord?
Little bit.
I may be pardoned to make a mention, my lord.
Yes, sir.
This matter was there in the list on 22nd matter. They're there in the list. Though it was reached, your lordship has adjourned the matter to next week, my lord. But next could not.
It has not come.
No, madam. Therefore, I have tried, my lord. Can it be taken up tomorrow?
Next week it will come. Give it. 23rd.
Mention it, you were to fix the date today, but
The doctor's matters. No, yesterday we said to post it to 23rd.
I only have 10 years.
No.
Sir, my lord, already 12 years, 14 years we have been removed. Lordship has had everything only 2 minutes. I already have my lord.
No, we also say with
That's already the case is fixed and it will order you to pass the application. As you not supposed to. And that's what I, sir, do.
You tell your clients, judges are not good. They don't keep their words.
I can't say that. Force it.
It will come on 23rd. If insist that way, people may mistake some other thing. We agree with your request. Because it's an online court, people will mistake why this outgoing judge is so much interested in this matter.
I can't say put on vacation.
On 23rd you get.
My lord, 23rd, for another 2 years. My lord, I understand
23rd finally.
My lord, on 3 occasions it has been hard and released.
Yes.
That's why we're holding up tomorrow. Item 1. May I please your lordship, my lords?
Yes.
Tomorrow. Already 3 occasions it has been 9, 10.
A day after tomorrow. Put it day after tomorrow.
My lord, it's a very
70.
My lord, it's a very
It is not. 70.
My lord, it's a very peculiar case, my lords. That the opposite party are very poorest and obese of the state, my lords. They are not having a shelter, neither a one-day meal. What happened, my lords? Their number 16 batch number of applications are filed, and this court has allowed, my lords. They are not out of the batch. 3 numbers of applications have been challenging writ appeal. It was dismissed. Further, the state has gone to Supreme Court. It's a funny compensation matter. Those who have lost their homes in 2019, my lords.
No, yeah, you want it to be listed.
Give that limitation into that. Why not give
Also imposed fine of 10,000 rupees to the state, my lords. Cost. Then also state has gone for review. Also been dismissed, my lords.
Now we put it.
May I please your lordship? My lord, your lordship had kind enough to grant me favor for amendment of my writ petition. But later on I regret and repent that I had forgot to mention one date of the order. So another application I have filed. My lordship, please.
Your lordship, this is a phrase admission. The present petitioner challenges the order passed by the Central Administrative Tribunal relating to recovery.
Yes.
Your lordship, item number 1. The matter
number 1.
Yes, lordship. The matter can become after one Mr. Swine's a personal difficulty can become after one.
On the ground of difficulty of the arguing counsel for the appellate. Yes.
Item 2, WBC 16990/2026.
My lord, in this case, we are challenging the impugned order at Annexure 1 in 2 ways that has been passed analogously. In one case, the Honorable Court has passed this order.
Conflicting orders.
No, my lord.
Similar orders.
Similar order. First, it is the impugned order is also show the same one judgment, but 2 ways. But here only.
Notice is already ordered.
In that case, notice has been
issued.
Yes, issue notice. Only one thing, my lord.
What?
In that case, it inadvertently written that the issue emergent notice, learned CGC on request of the copy accept notice. But here the private opposite
the private party.
I am the for Union of India. Senior panel counsel.
So that order needs to be rectified actually. Move it, otherwise notice will not go.
Oh, my lord, I will intimate him. I will intimate him.
Heard, Burnett CGC.
No, my lord, senior panel counsel.
Senior panel counsel appearing for the petitioner. First off, he submits that the fact matrix of this case is substantially similar to the one in WPC number 16955 of 2026, wherein already notice has been ordered, and therefore similar treatment is given. First off, we agree. Next, issue emergent notice. Call along with the WPC number 16955 of 2026.
My lord, IA contempt.
Contempt is filed.
Contempt they have filed, my lord. I therefore stay.
They have filed contempt now.
Yes, they have.
The number, contempt number.
The contempt number inadvertently I could not bring this. But that is within my. They have intimated.
In OA, no? OA.
OA, my
In
lord.
OA.
IA state.
Learned senior panel counsel draws our attention to the application 9 number so supported by the affidavit, telling that the order impugned in the petition is now sought to be enforced in contempt jurisdiction, and therefore the same requires to be kept in suspended animation till next date of hearing, at least till next date of hearing. First of all, better required consideration. First of all, in the above circumstances, the contempt proceedings, if any, at the hands of the CAT shall not be precipitated till next date of hearing.
Public. Urgent check.
Well, this is a MSME. This is a MSME unit, my lord. There is a overdue amount of 7 months term loan, which comes to 7,18,000, and a overdraft amount of 2,10,000 in the CC loan, my lord. And in 2025, till 2025, is up to date and paid 28 lakhs. And they have also paid for a reschedulement, but they have not rescheduled. And again, it is on e-auction has been put to e-auction. The several decisions of the Hon'Ble Appeals Court in MSME matter, it has to be revived by the.
This contention you can take up before the tribunal.
Well, this is a MSME unit. Well, his petitioner is ready to pay the overdue amount. Yesterday also I mentioned. Today he already prepared 7 lakh. What is the exact amount?
Now total dues is about 70 lakhs.
Both the accounts they have joined.
2025 it was NPA. On his request, it has been regularized. And in between 5-6 times, we are just pressuring him that tomorrow going to be NPA, if will not deposit. By that way,
how much money they should have deposited?
70 lakhs as on date.
Is outstanding.
That is 2 accounts they have more smell. Yes.
When you asked him to make the payment several times, what was that money?
About 2 lakhs, 3 lakhs, 4 lakhs.
How much it is now?
Now it is
assuming that there is no NPA. What is the amount payable? That component.
You
want money. Bank wants its money back.
That
anything else.
I am every day. I am before this standard. That
what is that money? He will pay it now.
As on date, it is about 70 lakhs.
Again, you are doubting total to say this.
Overdue is more than 20 lakhs.
More than 20 lakhs.
More than 20 lakhs.
As per my calculation, 7,86,000, 1,08,000, 7 months. I have given the account statement, my lord.
Calculation you have given?
I have given the calculation, 1,09,000, 7 months due. That is 7,82,000. He made the draft, my lord, today already. And overdue, overdraft against the CC loan is only 6 months interest. That comes to 2,10,000. 2 accounts, they have more.
I am telling 20 lakhs. What he is telling is also about 20 lakhs.
No,
10 lakhs.
You pay 10 lakh rupees now.
Yes, my lord. Today I have already prepared 7,82,000 and 2,10,000.
You have prepared this one?
Yesterday I mentioned before lordship. Accordingly, I instructed him. He is already prepared the draft, my lord.
Prepare the draft?
My lord.
Where is that draft?
But he is on the coming on the way.
To get it by
7,80,000, 2,10,000.
WhatsApp.
Yes, WhatsApp.
There is 2 accounts. One term loan account is also there.
To that one also. Just show that. This is in respect of one account.
2 accounts. 7,82,000 against term loan, and against the CC loan, 2,10,000 is the interest part. It comes to 9,90,000.
Then my lord, may I request, my lord, let it come.
Let him pay 10 lakh rupees.
Yes,
so that bank will have part of the money. In the event what he says is not true, and what you are saying is true, we will dismiss the petition. You will return the 10 lakhs to his account.
Yes.
That will help you.
That money is coming to you.
Ah,
What I am telling.
Money,
What I humbly submit.
what we will tell you.
Let it come.
Get that. Maybe one day.
Today I will
I'll come up with
Let it
exact overdue, my lord.
Huh?
Exact overdue.
All right, you come with that also. Now, at least get that. See, it was Carlyle, Thomas Carlyle, the great philosopher, who said, money is my God, and how to get it is my religion. First, get that money. Get that money. Yeah. Heard
Prior to Sunday.
Huh?
My lord,
today I will pay the debt.
Today itself he has to make the payment.
Right.
Remaining that 80,000 or 90,000 to make good debt.
Another debt I will pay.
Within 1 day you can make that. That will help you.
Let me submit one more. That let him pay this amount and let him communicate bank. I will ask the bank to communicate what is further overdue amount. Let him pay it.
That's right. That's right. Then with that observation, we can dispose of the petition itself.
My lord, I will kindly keep it.
My resettlement application is there. Let that be considered.
Fee payment structure is based upon the hearing or
No, my lord. My lord, I must have experience. I have never requested other matter.
Numerous things.
But here, why you are giving this bank, several matter has been disposed of by this court, but this bank, the conduct of this chronic defaulter, chronic continuously defaulter there. And by this way, bidder is also, once court is matter is subject, bidder is also not coming for this year. We have to arrange the bidder also. For this,
when the scheduled auction?
Auction
22nd.
22nd. We will, you make.
Today I will make payment 10 lakhs, my lord.
10 lakhs.
And within a month I will pay rest of the, what they have intimated me.
No, we don't believe you.
No, my lord, it will record my commission, my lord.
No, we believe you, but not your client.
No, my lord, I know, my lord. If I will submit my client's position, my lord, they have harassed the MSME amount.
What harassed? You make a repayment, you are a borrower.
My lord, why I am saying so, my lord?
What you are saying?
My lord,
it's the duty to make the payment.
My lord, 28 lakhs he makes the payment with a observation that they will grant the working capital of 30 lakhs. But they have not granted working capital.
Therefore,
that's why he is defaulting for till date. And they have not estimated the loan amount. What is the exact?
Ask your client to take the payment.
Yes, my lord, he will make the payment, my lord.
Duty of the.
He will make the payment.
He should be humble and meek.
Yes, my lord, he will make the payment.
Cannot raise the voice at all against the lender.
He will make the payment, man. Today he will. I already instructed him that you prepare the draft because yesterday I mentioned before this honorable court.
You should know where to stop also.
Yes, sir.
That is advocacy. Or you will go on arguing till cows will come back. Challenge in this petition is to the coercive action of loan recovery. First off, petitioner claims to be an MSME unit, and therefore its counsel tells us that it is entitled to certain privileges that are usually not available to the other kind of borrowers. First off, he also tells at this stage that his client is ready and willing to clear all outstanding amount, overdue amount,
and overdraft amount. Overdue in term loan and overdraft in CC loan.
Overdue in term loan
and overdraft in
CC loan. First of all, learn the next paragraph. Come on. If a reasonable accommodation is granted, first of all, he hastens to add that today itself his client will remit a sum of rupees 10 lakh to one of the accounts, two accounts, to the accounts in question before sunset.
By way of draft.
Whatever. First one. Next one. Learned panel counsel appearing for the OP Bank immediately opposes the petition in general and the grant of any relief, interim relief in particular, highlighting the culpable, allegedly culpable conduct of the petitioner borrower. First off, this aspect we can examine on the next date of hearing, if and when the petitioner leaves up his words. First off, if he does not come up, the petition itself can be thrown out. Yes. In the above circumstances, the subject application in I number so and so supported by affidavit is favored in part. First of all, the coercive proceedings by way of auctioning of the property scheduled to be held on 23rd of this month is deferred sine die, subject to petitioner making the payment of rupees 10 lakh to the accounts in question before sunset of the day. First of all, petitioner should also be ready and willing to make the deficit of the overdue on the next date of hearing. First of all, call this matter on 20. For this, we'll call it tomorrow, so that you should show the bona fide. Call this matter tomorrow for showing the bona fide compliance. For showing the bona fide compliance. First of all, petition.
Next week.
Not
today.
Today you should make. Tomorrow you should.
But
make.
today I will deposit the draft copy, my lord, in the court itself.
What? Why court? We have not lent money.
My lord.
Bank has lent money to you.
No, today we will deposit the draft copy in the court, my lord.
Why? You deposit that money in the bank. If they deposit, you accept it.
That is LPA account, they will not accept.
I know, just now I
They intimate.
just now.
The bank is direct.
I will tell whatever you will deposit, accept it.
No, not whatever.
10 lakh.
Directed to accept the aforesaid specified sum if tendered by the petitioner. First of all, maybe that it can be kept in escrow account as well if needed. Okay. Call tomorrow.
Today after launch, my lord. After launch, you will
No, tomorrow not after that.
Today, my lord, after lunch.
Today after.
Today after lunch.
Make payment.
Yes, ma'am.
Tomorrow, fast and late.
Tomorrow I will not be there. Tomorrow I will not be there.
Tomorrow
I will not be
you
there.
are in difficult.
Puri again.
On 17th we will call.
17.
But call this matter on 17th.
Total dues position maybe. Total, I have some.
Sentence. Learned panel counsel submits that the total amount now outstanding is a
about
sum of
70.
rupees
70 lakhs.
about 70 lakh. Okay.
Urgent copy, ma'am.
That carbon copy to be supplied to both the states right now. No. But they ask to.
Item 4, WPC 21612
Yes, sir.
But here, the petitioner who had taken a loan from the bank, even after depositing almost the entire dues, presently a notice has been issued for sale of his residential house. Claiming
When amount was taken?
amount was taken way back in 2012, and
One second. How much money, sir?
if your lordship will kindly come to the document at annexer
2 crore
7
lakh 57,000.
Yes, your lordship will kindly come to page 42, annexer 7. There it is clearly mentioned,
57.
page 42, annexer 7.
14 lakh 57.
18/4/2012, outstanding is 2,75,017
13.
2012.
There you will also will see at column 14/3/2014, 2,21,000, 2 crore 21 lakhs, and that was recovered by of sale. Ultimately, if you also will kindly come to page 43, the total outstanding as on 31/1/2019 was 12,62,261 only. Page 43. 12,62,261. And
This was on?
31st January 2019.
Towards interest.
Only interest, and I will show to your lordships, page 44, annex 8. They've written balance of rupees
2 crore.
2 crores of the for total due signed by the Axis Bank. This was when the matter was transferred. Axis Bank transferred the recovery.
2012, 14.
Yes, it was for recovery from me through the agent. So, if your lordship saw the amount now only 12 lakhs. Prior to that, if your lordship and the petitioner had come up before your lordships in a writ application, there the order your lordship may kindly look at page 38.
38 is the order. The so operating portion is page 39, last paragraph. Therefore,
In view of the effort.
yes, in view of the efforts submissions made, we are of the considered view that there should be no impediment on the application made by the opposite party number 3 company to take vacant possession of the factory, including land and building, as well as plant and machineries mortgaged by the borrowers. We are therefore of the considered view that since there is no impediment to the application made by the OP number 3 company, the company is at liberty to proceed with the same subject to the condition that the vacant possession of the mortgage property shall be handed over to the auction purchaser only after receiving the balance consideration money along with the interest, if any, on and from the date of auction. The entire auction price of 2 crore 95 lakh crores will be credited. And now, interestingly, you will also come to page 45, annexation 9. This auction sale notice of my residential house. Paragraph 1, 2, 3, 4, 5, 6 minutes. Notice is hereby given. You got it?
6.
Notice is, yes, notice is given to public in general and in particular to the borrower, guarantor, that the below described immovable property mortgage charged to the secured creditor will be sold as on basis, and without any question, 31st July 2026 for recovery of rupees 2 crore 75 lakhs due as on 18/4/2012 when they have recovered the entire amount.
2.95 you have paid. You have paid.
No, they got it by your sale of the other plant, machinery, everything else.
They have credited that money.
Yes, that is sold to your lordship.
Well,
That is 2.95.
Yes.
That was an order to sell it.
No, it was sold. The Miller's auction purchaser deposited. They adjusted the amount against my loan.
Possession of the property was directed to be given.
I will be given. Now the residential house, now they want to sell for that amount of 2014. Sell notice.
For the same amount.
Yes, lordship, look above. Annexation 9. Annexation 9 and the loan is of 2014 when I have already paid everything. Page 45. Lordship, kindly look
the
at.
price for the below mentioned property is rupees 1 crore 48 lakh 20,000.
No, sir. Yeah, again, 6 paragraph, sir. City se koile notice is given to the public for recovery of 2 crore 75 lakh 17,000 as on 18/4/2012. 18/4/2012.
18/4/2012.
When the amount has already been deposited, I'm showed to also the account statement. Only 12 lakhs was due. Now they are claiming again.
No, that can happen.
Yes.
Now, how that can happen, we don't understand.
That's most strangely they have issued a auction notice. And they in violation of the lordship's earlier order, they said that no interest or anything will be charged against me. But they've done it. Page 39. You'll also the entire auction price of 2.9 crores will be credited in favor of the petitioner's loan account from the date of auction. The petitioner shall not be saddled with any interest and cost including the agent fees as well as security charges from the date of auction. In spite of that, now they are claiming 2 crores.
Which bank it is?
No, it's a recovery agent belongs.
Axis Bank.
It's a scheduled bank.
Yes, of the scheduled by Axis Bank. Now the recovery
Agent will recover that.
Yes, no.
You have heard. In 2023, yet another WP.
No, that 2014 WP was disposed of in 2023.
Direction to take up the matter with the SAHOO. Under
the lordship said that you avail your remedy available.
according to
No, actually, not because his property itself is sold.
Yes. And interestingly, section 31(1)(j) says that if the amount due is less than 20%, surface will not be applicable.
No, that is, we do not have that figure with us.
Figures, factors, only we have to go by yours.
Right.
But instead, what we will do is we will issue emergent notice, which when we will record your submission that entire money is paid.
Paid in this sense, it has been adjusted in auction.
By auction proceeds are appropriated to the loan account.
Yeah.
Heard, learned senior advocate, Mr. Sykes, opinion for the petitioner borrower. First off, he submits that the entire money due to the account in question has been appropriated from the auction proceeds of the security property years ago, and that the possession of the auction property has already been delivered to the auction buyer pursuant to the order. Where is that order which you are in?
Yes, sir. Pursuant to
That is order dated
22/10/2014.
entered in miscellaneous case number 17747 of 2004,
In WPC number 7715 of 2014.
which arose from WPC number
7715 of 2014.
2014. First one. Learned senior advocate repeatedly asserts that no amount is due by his client, and therefore the auction now sought to be conducted in respect of the residential house in question is a falsome. First one. A perusal of the case papers prima facie gives an impression that the submission at the bar is true. First one. Next paragraph. Learned senior advocate drawing our attention to the application in IN number so and so, supported by affidavit, argues that if the scheduled auction is not halted, his client runs the risk of losing the residential building itself, though no amount is due from his side. First one. This requires deeper examination after having the say of banking question. First off, denying interim protection would be doing avoidable injustice to the petitioner borrower. First off. Next paragraph. In the above circumstances, the subject application having been favored, all recovery proceedings, including auctioning of the security property, are halted till next date of hearing. First.
I take notice by register, still post me. Notice by speed. By speed.
Item 5,
Before I start my case, but I must candidly confess that this is a purely mercy petition. But
we have writ jurisdiction, but mercy jurisdiction only present it as God.
No, what I am saying, he has gone through a storm when he was before this honorable court in the earlier occasion. He had given a false information. He had given a false information before the court. For that, your lordship came heavily upon the petitioner. Your lordship may kindly see page 26. Page 26.
Go to 26.
Page 26. After having noted that he has committed a grave offense and everything, your lordship finally directed these things. Because there, the bank had come up against a proceeding under section...
Where is 20? Page 20? Which 26 of?
126. 126. 126, sorry. That's you got it.
Yes.
After noting that he has committed a mistake and he has given a wrong affidavit, your lordship finally, in the above circumstances, the petition is disposed of the following directions.
Yeah.
The bank had come upon against an order under section 14, where the collector had refused, saying that an inconvenience deed has gone. But that was not a fact. So your lordship quashed that order. First order.
No, he has played fraud.
Yes. By
the bank.
Yes.
And on the bank manager.
Yes.
And on this court.
By saying
therefore, we gave the penalty order of 5 lakhs.
Very, very correct.
Yes.
I have no issues with that. And secondly, your lordship directed imposition of fine of rupees 5 lakhs.
5 lakhs.
Then an undertaking to be given that you will give a
fine. Penalty.
And then an undertaking to be given that he will give up possession.
Correct.
All those things have been done.
Has he given the possession?
Yes. Possession in fact has been taken away. Property has been, my residential house has been sold. Now it is fixed for the mill to be sold. At this stage, I just bring to your lordship's notice the last direction. Lord, with all the ire, Lord, your lordship was even kind enough to give this direction. With all the, Lord, page 128.
It is open to.
it is open to opposite party number 3 to make a fresh OTS offer by making payment of requisite amount while computing which the amount already paid by him be taken into account. However, such liberty avails him only on the payment of penalty amount as mentioned above, which I have already paid, Your Lordship. The petitioner bank shall take a fresh call on OTS offer in accordance with the extant RBI guidelines and inform result of such consideration of within an outer limit of 2 weeks. Until that happens, the security property shall not be. Lord, with all these things, Your Lordship were gracious enough to. But I immediately, after 2 days, next page, 129, I gave the OTS offer. Let me bring to Your Lordship's notice, the outstanding was some 11 crores some odd. I gave an offer of 10 crores 7.
70 lakh.
2 days
7
thereafter.
lakh.
Yes, 10 crores 7 lakhs. Immediately, pays 130. After 2 days, they cryptically rejected it. Without it.
10 crore 7 lakh.
Yes, 10 crores 7 lakhs. Yeah. They cryptically rejected without any receipt. Now the residential house has been sold. I have lost possession of it. But that is why I started with it. Now I am prepared to pay the entire dues within 3 months. Within 3 months, I will pay the entire dues. OTS, they say that they are not acceptable to 10 crores 7. So the entire amount is about 11 crores somehow. I have arranged a buyer who will take the property for 12 crores. I have given that, brought it to the notice of the court, of the bank also. So my only submission is that this is what discretion I beg for, that within 3 months I'll clear that is all. That is all.
Do not use the word beg. They are all lawyers. Lawyers is a great institution.
Lord, the language being used, that is obsolete. That is obsolete. Your Lordship is right. That is obsolete. But what is happening?
Now you have taken possession of the property. Slowly, one by one, answer our question.
My lord.
1 second.
Yes, my lord.
You don't want to listen to us? You don't want to listen to us?
Yes, ma'am.
You will listen?
Yes, ma'am.
Yes. Has he complied with the order which we had made in his case? He was, we bitterly treated because he deserved that treatment is one thing. But what Lajja Council says, even there we have treated him with respect, honor, and mercy. Saying that his OTS application should be considered. You did that. No problem. He has given 5 lakh rupees penalty. Has he given? We are asking him. Has he given 5 lakh rupees penalty? Please answer.
Not to me, I cannot say, because that matter is today I come 18. And this is direction of the SP man. So SP.
He says he has paid.
Yes.
That is not to me, to the legal aid man. So
legal only.
Yes, I can only SP can say that.
Whether you can't, whether
Yes,
no, he is saying no, he has paid that. Anyway, we understand that. Now he says, whatever has happened. Even at one particular time, Valmiki himself was a criminal, but he became Valmiki Maharishi. Is it not? You have seen the story of Angumalia. Oh. Therefore, see, we are court. We have to be merciful also, even to the dreaded criminals. You have seen what treatment the apex court gave to Kasab. Is it not? A foreigner, enemy country, and the man who killed so many people, caused devastating damage, how he treated him. That is how Indian judiciary stands tall in all civil jurisdictions. That is the reason why the American court said, let Bhopal Carbide, Union Carbide case be tried by Indian court. Just giving you, highlighting that one. Now, he says, it is not that I am running away. I will give entire 11 lakh plus interest. Give me some time. That time also, 3 months he is asking. It may be little longer. You come out with your proposal. You want money.
Yes.
Yes.
3 things, madam. What my lord senior submitted, the bank has just taken physical formal possession, only lock and key, and his assets are there. Inspector Manual's direction, he has not complied the same, and we have repeatedly requested him, and he asked us to give time and once I again, that's why I have filed a contempt, which is when you manner. Yesterday I have made mention, the lordship directed it in number four.
Why he has not taken all the commodity?
Those letters I will read.
No, then we are not interfering. We are dismissing this and we'll take action in the contempt forms. Contempt 1 crore rupees. Fine of 1 crore rupees.
Not that, I don't think so. Not that.
Your question is not thinking.
No, because
Has he complied with this order?
but as per my instruction, I think he has complied. But
Has he complied?
Yes, complete the order. Some household articles.
Why has he not taken?
he says that some household articles are there.
You will make an order that the household articles will be taken by the bank itself. Distribute among the employees of the bank.
There are 2 rented persons staying. They have taken the household articles.
We do not want that. Whatever is not there, that will go to the bank.
But we have handed over the key.
The key, we are handing over key. What we should do with the article if you have kept a cobra inside and you have given the key? You mean to say that the bank manager should not have the risk of right?
Fridge and TV.
Fridge, TV. Your lordship may say that the whatever articles are there, but physical possession, but net result is I have given up possession.
Correct, but the articles are not removed. You will make an order now that the bank will take the articles home and distribute it amongst the poor people, poor employees of the bank, peons and others.
Page 18, what he has made, only I have given. Page 18, the contempt is happening.
Serial number 18.
Page 18. Contempt of PSN University. Page 18.
Contempt of please.
What are those items?
Fridge, TV,
Household.
What are they?
bed, cupboard, fridge, TV like this.
University page 18.
I have also given that letter at page 144.
We have enclosed that letter, man.
Yes, teachers, furniture, schools. And there I have also requested the police. The police has not helped me. That is available to my website page 20.
No, he has asked for 2 weeks time to remove the article.
Yes.
Possession he has given to him.
But since the matter 46, 6, we are running after him. You know, see, past order 22.5. Thereafter, we are running after him 2 weeks, 3 weeks, 1 week, like this now. This is our second.
But possession he gave same day.
Lordship,
Yes.
we have.
Fine.
Number 1.
Fine.
Now lock and key with you.
Lordship.
Outside, but inside lock.
No.
Yes, please. Key is on his custody.
Break open. Break open the key.
That
And the
is
police is not cooperating also.
Huh?
Yes, ma'am, I have here also.
Mr. Mishra.
Yes, talking to affairs with the local police. On 4/7/2026.
Now why he has not given, why he has locked it? He appears to be mischievous fellow.
Oh, he has given the
He
key.
is elsewhere.
He has given the key. He has given the possession.
Keep your
Only
client-
household articles. He has
Keep your client present. We want to cross-examine you. At 2 o'clock he should be here. Otherwise we'll direct his arrest and detention right now.
His-
Right now we'll direct his arrest and detention. He cannot go on playing with the court.
Your
Why
lordship,
does he?
he has not disobeyed your lordship. Your lordship may take it from because
No, we'll not take it. Keep
because your
it.
lordship sees that letter which my lordship is showing. I have also annexed that 144 page 144. Your lordship.
We will cross-examine him. Ask him to be present before the court at 2 p.m.
2 p.m.
He should be here at 2 p.m. Otherwise we'll direct the police to bring him here.
Tomorrow, your lordship is tomorrow.
Tomorrow? All right.
Tomorrow first.
Learned counsel for the bank submits.
As for the
Huh?
these two matters.
Trying to submits that the petitioner has put his lock to the inner part of the house in question, and thus he has shown a scant respect to the court order. First off. This needs to be ascertained from the petitioner party in person, and therefore he is directed to be present before the court personally tomorrow at 10:30 AM. Hey. Failing which, very next moment, the police shall do their job. Okay. Call tomorrow.
Lord, your lordship, just your lordship has got, your lordship
They
has,
have to assert.
just, yes, your lordship.
It's 40
What
for those who comply with
Yes,
the order.
not complied with
Others
the
will-
document which they are showing. Your lordship may kindly see the document which they are showing.
Let him, not you.
No, they are showing, the bank is showing. The bank is showing.
We have also encouraged that document.
The bank is.
But why he has not taken the goods?
No, goods, my lord, I have asked for the, because.
He's not you. He should come before the court. Otherwise, we will issue arrest warrant.
No, he will come. He will definitely come.
Tomorrow, ask him to
But
come.
possession has, your lordship may take it that it is admitted position that possession has been.
Call this matter tomorrow along with the
407.
contact signs. Okay.
Item 6, WC 2166
So I'm serving the copy of this, send to the council for the bank. So you lordship.
What is this matter?
But the demand notice issued by the bank to the petitioner asking for.
9,43,60,440.
The lordship, that is by 29/5/2026. He has to deposit the amount in spite of depositing 16 lakhs regularly to the bank. But because of COVID-19 situation, he defaulted in making payment.
COVID-19 over years.
Because your lordship, in the year 2018, he incurred loan for establishment of fly ash brick.
What is the amount due as on today?
Your lordship, as on today, that is 20 lakhs 17,618 as mentioned in the notice.
How much money he will pay now?
Lordship, 10 lakhs, your lordship.
10 lakhs.
10 lakhs.
Not kindly. The loan has been availed in 2018. Account has been turned empty 30th/11/2019. So he has taken two loans. One CC, another term loan.
How much?
Term loan, total 15 lakhs. And thereafter, he has only paid, as per the instruction of bank, 2,97,732. And as on 13/7/2026, due is 22,95,266. And the account turned empty.
22,07,865.
22,95,266.
About 23 lakh.
Around 23 lakh. The account turned NPA on 30th November 2019, prior to COVID. And it is a quick, in our banking parlance, it is a quick mortality. It means he has taken CC and term loan. He has not paid both. Only 2,97,732. When we have issued 13.2 and thereafter 13.4, taking symbolical position, he has come forward with these applications. So for long 2019 to
let him pay the 50% of the amount in 2 weeks. Then we'll examine at least bank. What is the object of NPA certification? Then get the money back. He will give back.
Your lordship may kindly see.
This is a perfectly mercy petition.
16 lakhs, your lordship, my counsel is not expressing that I have deposited 16 lakhs.
When?
Your lordship may kindly see page 27, annexure 1.
When it was?
It was by 2025.
2025.
28/12/2025.
15/12/2022.
Your lordship may kindly see page 27.
Application so.
That was 2022.
And rest balance has been settled with as interest on 27/26.
Total credits, your lordship, 16,048.
These are all
16 lakhs.
Brother, these are all accountancy matters.
Lordship.
Accounts will reflect. It's a scheduled bank or nationalized bank? SBI. Statutory bank. So why they will lie? That all they will be audited by the Auditor and Controller General of India. Controller, CAG, Controller and Auditor General of India.
Because the thing is that your lordship is suffering is a heart patient, and because
everybody after taking loans will have the same story. In fact, after retirement, I want to read a book.
This is not a story.
All cock and bull story.
No, your lordship, it's not a story. Your lordship, it is supported by documents. Your lordship, it is not.
Then we will dismiss this.
No, your lordship may pass order that.
Pass order.
No, your lordship may pass order directing the deserving amount to be paid by the petitioner.
Where will you pay?
Within a period of, your lordship, 1 month, because I have submitted, earlier I submitted representation by saying.
Amount within 1 month. Like within 3 fortnightly installments, 1.5 months. Like, yes. And other things, the other judges will look after. Challenge is to the coercive proceedings of loan recovery. Obviously, taken under the provisions of the Surface Act 2002. First one. Learned counsel for the petitioner highlights some financial difficulty as to why the repayment schedule was not adhered to in respect of 2 accounts, loan accounts in question. First one. Learned counsel appearing for he further submits that if a short accommodation is granted, his client would initially make 50% of the outstanding money within outstanding money with some installments, and he would also come out with a plan for making the repayment of remainder. First term. Next paragraph. Learned the panel counsel appearing for the bank in his usual vehemence opposes the petition, highlighting the arguable conduct of the petitioner. First off, he tells that the story of COVID pandemic 19 is only a cock and bull story, in as much as long before the COVID had set in, he had defaulted. First off, be that as it may, first off, justice of the case warrants that some interim protection, of course, subject to conditions, needs to be afforded. First off, next, in the above circumstances, the application in IN number so supported by affidavit is partly favored, conditionally favored, and the coercive action for recovery of possession, for taking possession, is suspended subject to the following. First, petitioner shall remit 50% of the outstanding amount in respect of both the accounts in 4 equalized fortnightly installments, 2 months fortnightly installments. First term. Next point. Petitioner shall also come out with a plan of prepayment of the remainder. First term. Call this matter after 2 weeks for reporting payment of first of the installments. First term. Next part. Petitioner is put to warning that in the event the condition mentioned above is not complied with, his petition would suffer rejection on that ground per se. Okay. Next.
Content 3790
Compliance of order of this Hon'Ble Court, my lord.
Notice was issued.
Fresh
matter. What is the order, brother?
Order, my lord, at 17/3/2026, page 9.
Implement this one of the police service. Okay.
My lord.
Yes. 4th of August. Yes.
Item 8, content 3959/2026.
Your Lordship, non-compliance of Your Lordship's order dated 22/4/2026, in which Your Lordship has directed to pay the...
All right. Police notice has to go. Yes.
Item 9, content 3990/2026.
And also content, my lord.
At page 10, my lord, I have invoked the clause of 24% interest in this case, pursuant to Your Lordship's order. They have failed to pay it within 2 months. The order was passed on 9/4/2026.
But return not service is not done. Process is not taken.
But I have served it. That copy they have received it in person.
They have received in person.
They have received in person.
But court process you are not taken.
Court 11. Court had not directed.
No, court has not directed.
No.
What was the order here?
Well,
Page 10.
Go to page.
we have copy of order to be acted upon by all concerned.
15% or 7% for the declared amount during the period. Yes, Mr. Mandi. Remittance of interest in terms of to be made within 8 weeks.
Yes, ma'am.
Page 11.
May I pray, my lord? May I, my lord? It is first time. May I take instruction, my lord? So far this payment, first time.
Then we will issue a police notice. Issue police notice. The returnable within 10 days. Post it on. Call this matter on.
Item 10, resolution 27313 of 2017.
Though duty is issued, but yet not complied.
Notices are been issued.
Read was issued, man. Not, it has come by the registry that
Compliance report.
Compliance report.
to comply with. Dear my lord, you have to take instruction because my lord's order is on 7/4/2026. And so far this compliance is concerned, they have communicated, but what action they have taken in the meantime, we have to take instruction.
Call tomorrow. Strict action follows if compliance is not reported.
My lord, tomorrow.
Tomorrow. Something I have to do before I admit the office. Yes.
Tomorrow.
Item 11, new table 126 to 124.
How many days delay? There was one delay, we have 123 days.
Already 123 days.
In one case 123,
In another case 177 and 295.
Longest is 295.
Longest is 295. For the
order. Number will be the Krishna number will be followed.
Well, other two sub-items.
Sub-item
also same.
The only number of days will be demanded.
Yes, ma'am.
Delay condoned.
My lord says pass this order in case exactly.
Delay condoned.
Yes.
Yeah.
Item 12, new table 2 of 5/2024.
Item 12, my lord, though it is a state appeal, we don't want to proceed because in the meantime this has been implemented, disposed of because that Jita Lua case is there. So for the rehabilitation is concerned, and I have received this notice also from the authority itself.
Give that. State and its officials are in this court appeal for laying a challenge to a 11th single disorder dated 1/12/2022. This
is the letter.
Respondent employs WPC number so and so. First, let the AGA appearing for the appellant state has produced a copy of the letter dated 8/7/2026.
The copy of it. Produced to action.
I will give it.
Wherein
this can be Xerox.
The Commissioner cum Secretary to Government has instructed the Office of the Advocate General to withdraw the appeal. First one.
The next page also at the top also it has written.
Appeal is disposed of as having been withdrawn with a direction to give effect to the impugned order within an outer limit of 8 weeks. Failing which, at the next level of the legal battle, the serious view would be taken. Okay.
Item 13, new table 5/05/2025.
To send a copy of this order to the respondent by speed portion.
My lord, item 13, I am on behalf of Mr. Vibhuti Vishnu Swami, my lord. He is appearing for the appellant. I am permitted to withdraw, my lord.
You want to withdraw?
Yes, my lord.
Why?
Actually, Mr. Swine lacks in court number.
Counsel for the appellant has filed a memo this day in the open court seeking leave to withdraw the appeal. First off, memo reads as under. Next one. In the above circumstances, the appeal is permitted to be withdrawn and ordered accordingly. Registry to send. The other side is served. Not served. Not yet served. Registry to send a copy of this order to the respondents immediately by speed post. Yes.
My Lord, this is appeal by the state.
Yes, Dr. Panda.
The claim for differential arrear salary being guided by the Supreme Court decision in Union of India versus Tarfem Singh, we had filed this. In the meantime, coordinate bench, your lordship judgment is staring at us, my lord. Matter is covered.
657 days.
And in the corrected.
Matter is covered by your judge.
Have you started writing a book on service law?
Not yet, madam.
Not yet. Why? Hold on.
Article 15, we have been 1211 of 125.
First day disposal, my lord. Page number 20, my lord, and Annex 1. Running page number 20, your lordship, kindly have a glance. That is the impugned order. The first day disposal, relying on a case which is not applicable to the facts of the case, my lord. We had contended that, we had argued that, but no opportunity given to us to file the counter to distinguish the facts. And the case was relied upon and was disposed of by a...
Read para 4.
Yes, ma'am. Mira.
Para 4 of the judgment.
But if it mentioned that even though land advocate, government advocate contended that the issue is not covered by the aforesaid judgment, but this court, after going through the judgment, finds that the claim made in the present petition with regard to the impugned order is covered by the judgment dated 9/1/2025. Because on the self-same issue,
Not self-same. We will distinguish right now.
Yes, let me, because
Where is that 9/2025 order?
yes, ma'am. That is a page,
Page 22.
Page 20. From page 22, it starts me. On the issue that the petition, in that case, Miller, the petitioner had issued, had produced a fake BD certificate, Miller. A criminal proceeding was initiated. At the same time, a disciplinary proceeding was initiated. But in that disciplinary proceeding, the Honorable Single Judge found that the procedural irregularities for which the impugned order was directed to be quashed, the impugned order was quashed, and the petitioner was directed, in that case, Miller, to file his written note of submission and to participate in the proceeding. And the same issue in my case, Miller. And accordingly, it was quashed because the imputation of charges, you may kindly see in my read.
Asked to participate in the disciplinary action.
Yes, Miller. The Honorable Single Judge had directed, had been pleased to quash the impugned order and directed me to participate in the proceeding, Miller. Nothing else, Miller.
One second. There should be pause between the two sentences. That CCA rules 1962.
It is a clear violation of the provisions as contained in the OCA rules. They sought of me the memorandum of charges, Miller. I sought for the documents. It was not acted upon. Thereafter, the order has been passed. That is the reason for which the Honorable Single Judge has been pleased to quash the impugned order and directed me to file the written note of submission, Miller. This is the only thing. I have to participate in the proceeding. The proceeding will not be go away.
How this case will apply to your case?
Because in that case, Miller, the same issue was there. That petitioner, the allegation was against that petitioner that he had produced a fake BD certificate. Because Miller, I am so also that petitioner, Miller, in the meantime, we have been regularized in service, and the OCS rule comes to our rescue, Miller. So that's why the Honorable Single Judge, while deciding the issue, that since that petitioner in that case was a regular employee, before terminating or dismissing him from service, the provisions as contained in the OCS rule has to be taken into consideration. That was not taken into consideration. In my case also, Miller, you also will find...
What was the allegation against him?
Same allegation, Miller. Only I have produced that fake BD certificate. I was appointed in the 2011, Miller. 2018, I was regularized on the self-same BD certificate. In the year 2021, they raised an objection that I have produced the fake BD certificate. Accordingly, a criminal proceeding has been initiated. At the same time,
whether charge sheet has been filed in that case?
The charge sheet
in criminal case.
Criminal case, charge sheet. No, that instruction I don't have, Miller.
No, that's required, no?
Miller. But on the self-same issue, for a moment, you will also kindly see in my read petition, page 42, Annex 8. The memorandum of charges of the dated 3/11/2022, but it was served upon me after 1 year. You will also kindly see on 26/12/2022. Sorry, Miller. It is a memorandum of charges on 3/11/2022. It was served on 12/12/2022. Just and I received it. I filed my objection that you give the documents to me. It was not given to me. Thereafter, the order was passed, Miller. So, taking into consideration this aspect, the Honorable Single Judge has passed the order, Miller.
But the facts are not matchable.
Yes, Miller.
How?
Because in that case also,
you tell what is the status of criminal case. Whether police have filed the investigation.
Miller, I will provide, Miller, but you will best 35.
Only thereafter we will hear you.
Yes, Miller, best 35. You will see. I am just clarifying the position.
The standard employee is directed to furnish the status report of the criminal case. That's a final form. Criminal case. Yes. Especially as to filing of the charge sheet, final report, final form. Is it under section 179? Not the section 179 of CRPC 1973. First, call this matter on 4th of August. 4th of August.
In the meantime, he may not precipitate his...
Whether contempt proceedings are there?
Contempt proceedings are there.
In the meanwhile,
it is not being listed.
Meanwhile, the contempt proceedings shall not be precipitated. Yes.
I could have submitted and distinguished, but your lordship's time is precious. Therefore, I do not.
There is some point. Not different.
Very clear.
What he says is maybe also
no distinguishable. 29 page 29. The so-called notice was not given in the earlier case.
But in this case,
we have complied the entire formality.
But
now
he did not find
his remedy is appeal. Bypassing the appeal, he has come before the court. Now we have exhausted the procedure. In that case, we did not. Therefore, the Honorable Court said
has been complied.
Yes.
Naturally, he did not file reply at all.
No.
Defense you did not take up.
And our
yes.
That is exhaustive.
Let us.
Yes,
you produce that.
Very good.
It's a covered matter, Miller. Your lordship's judgment is there with regard to regularization.
Sitaram Bera, yes.
Covered by judgment. How many years?
36 years. I already said
34 years. That
Mr. Panda will not allow you to argue.
No.
34 years.
No. Absolutely. That your lordship have laid down the law.
And same order.
No.
We can say subject matter of this is substantially covered by Mr. Panda.
Yes.
We'll say the subject matter of this appeal, but it is substantially covered by the principles laid down in this case.
No, I have not examined this judgment. Just now I have been supplied with.
Right.
But this is a case of a daily wage.
No, examine.
Examine.
And come back.
Yes.
Okay. Tomorrow we'll have it.
Yes. Tomorrow. Yes.
Item 17, DW 1615 of 2025.
May I please, Your Lordship? Delay of 3 days only.
3 days.
3 days. My friend is appear.
I have
through
appeared on
notice.
this man. We'll condone that deed. Whether yes or no, you are shaking your, you're nodding. It doesn't do it.
Only I would have time to prepare myself because.
No problem. This delay will continue.
Yes, yes.
Short delay proved in filing the inter-court appeal. Delay of 3 days proved in filing the inter-court appeal is condoned on the perusal of application in IN number so and so, which is supported by an appeal. First, all this matter. Next week after which
I will take some
2 weeks.
2 weeks.
2 weeks. First,
I will solve a copy to my friend.
you're welcome.
Get it.
Okay.
Item 18, W 5 of 2025.
My lord, item, if you come here, along with item 5, tomorrow your lordship has kept that dispose of matter. Only SP has to intimate my lords whether they deposited the cost amount 5 lakhs.
No, he said 5 lakh is paid. No?
Yes, yes.
Barring that, any other thing?
No.
Then we'll drop this matter. This we while order date is 22/5/2026 had hold of the subject petition with certain directions. First, one of the directions relates to payment of penalty of ₹5 lakh to the Legal Services Authority. First, we are told at the bar that this amount is already remitted. First off, in view of the above, no further orders need be passed. First off, however, if it is subsequently discovered that the remittance has not been done, it is open to the bank to seek the revival of recall of this order. Okay. Same person.
Item 19, W 818 of 2026.
Permitted to withdraw. What to withdraw?
My lord, I am for the bank, my lord. Pardon, my lord, I am on BC. Our presence be noted.
Correct. Petitioner seeks leave of the court to withdraw the petition by filing the memo dated 24/4/2026, which are the following script. Next paragraph. Learned counsel appearing for the OPs, OP Bank, agrees with the proposal for withdrawal. First off. Next paragraph. In the above circumstances, petition is disposed of as having been withdrawn, with no liberty to agitate the same for the appeal before the being. Withdrawn. With liberty to agitate the grievance before the DR. In that connection, all conditions are available.
Item 20, W 62049 of 2026.
Item 30 is permitted to withdraw.
This also?
Yes, ma'am.
Not happy with the court?
My lord, the collector has complied the section
already. The petitioner bank has filed a memo seeking leave of the court to withdraw the petition as having become infructuous. As it has become infructuous, memo reads as under. Next one. Ordered accordingly, petition is disposed of.
Item 21, proposition issued by 1 for 125.
Please, my lord.
Yes, sir.
Since that matter,
I don't have the behalf of Mr. Elphas Prashad, your lordship, for the opposite party. I pray for some time.
sometime.
Some days.
Lordship may fix the date.
Yes, your lordship. Can you short?
At the request of the council appearing for
Mr. S.S. Nasim.
Matter stands adjourned to 30th of July. Any entry model is there, sir?
Yes, interim order.
Then we'll post it after 4 weeks. Entry model will continue.
The difficulty in this case is that they have taken time on several occasions.
Anyway, you are protected.
I will not stand again now. Lordship may fix a date.
We'll say in the last week of August. Because date we cannot fix for the next bench. That's the reason. If this was the bench, we would have done that. In the last week of August 2026. First off. In the meanwhile, the interim order granted earlier shall continue.
Can I only request, my lords, under instruction, can we have it next week before whichever bench, so that if they are ready, we can argue it.
That's when they finally counter on the card state, your lordship. Any short date, once we finish.
Call the next week.
For filing the
At the request of so and so, who seeks to find the counter.
interim order to continue.
First, interim order to continue.
Yes.
Item 32, proposition 209 July of the
May I please continue?
Yes, sir.
Yes, the Lordship had directed me to take emergent notice on their bank. I've already served a copy.
I'm at instructions, sure, yeah.
Yes, sir. But I'm the auction purchaser.
This is forfeiture of the amount.
Yes, my lord.
Yes. You filed objection. Issue heard from the council appearing for the petitioner auction buyer who has a short grievance as to against the forfeiture of the amount paid by his client. Paid. Auction amount paid. The case is made out for issuance of emergent notice. First of all, the panel counsel so and so appears for the bank and seeks a short accommodation for filing his pleadings. First of all, we agree. Call this matter in the second week of August 2026. First of all, if the objections are not, if the counter is not filed in the meanwhile, right to file one stands forfeited. And petition averment may be taken with face value for adjudication.
There is an auction on 15th, my lord. There's an auction. Again, fresh auction they have called for.
Because there's no application for stay of that particular auction.
Not paid any application.
My lord,
There is
in
no
fact,
application
we
as
came to know later on, my lord. I have, by way of
application.
Yeah, I'm filing a memo, my lord.
And
Well,
I'm not,
that's true.
And I've not been summoned to that copy.
I'm giving a
I'll have
copy.
to give instructions.
This is an auction, my lord. And I'm an auction purchaser. I've paid substantial amount of money, my lord. Balance amount also, I'm ready and willing to depose it before this honorable court, my lord. If required, I'll also pay to the bank. 4th of May was the last date as per this statutory rule.
Forfeited amount.
Forfeited amount, my lord, against 82,65,000, I've paid 43,65,000. Balance is some 40 odd, my lord. I'm willing to pay that money.
No, that cannot be permissible, because the security interest rule, it provides that in the case, the upper limit is 90 days, and once the 90 days expired, it has to be forfeited,
But there is a subsequent that you are saying Justice Chandrachud's judgment.
Yes,
But subsequently one more judgment has come.
Subsequently the judgment is,
Do you have that judgment
Yes,
of Justice Chandrachud? Even there itself there is some keyhole.
Yes, my lord.
Keyhole left. Which is that paragraph?
Paragraph 118, my lord.
Read.
This is the last judgment, my lord.
Read. Discretion lies with the bank. Some discretion is given to the bank.
Exceptional circumstances.
That's what.
Yes, my lord.
Give copy to your friend also. At least that particular page should be shared with your friend.
Yes, my lord. My lord, I have
Together you read it.
Yes, my lord.
Or you give it to him. He will read it.
Yes, my lord. Paragraph 17 and 117, 1.
Thus, this court held that where extraneous conditions exist that might have led to the inability of the successful auction purchaser, despite best efforts from depositing the balance amount to no fault of its own. In such cases, the EMT deposit
may not be
by such innocent successful purchaser could certainly be asked to be refunded. In the case at hand, it is the respondent's case that he was unable to make the balance payment owing to the advent of the.
No, it's all right. In that specific case, we are not on that. We are on the law declared. What binds the court is under Article 141, law declared by the Supreme Court. What Supreme Court does is irrelevant to us because it does so many things on extraordinary powers under 142, etc. We are concerned. We are bound by what Apex Court says and not what Apex Court does. Because law declared by the Supreme Court. That is the expression in 141. Is it not?
Because if in that case.
No, you can. He has already paid and he says, remaining amount also he wants to pay.
I'll pay today.
But you want to file your counter. So you want to file the counter and you want to ensure the auction takes place.
No, Milos, in that case, Milos may list it tomorrow, Milos. I'll come with the instruction, Milos, whether the amount has to be refunded or not.
No, not whether the question is not refunded or not. That requires deeper examination. Whether auction should be held or not.
Milos, that particular IA is not on board today, Milos.
No, we will take it.
Milos, I have also
served with the court. IA is there, it is now given. You want to file objection. You file objection.
But IA is there.
I'll file an objection to the IA as well, Milos.
Now we will stay that. Now we
no, Milos may not stay, Milos.
You can say, you can argue. You cannot hold our hand while we are
no, Milos, if I may humbly approach, Milos may kindly grant
an application
one
is moved by the auction buyer who has already remitted the auction amount of rupees.
But 43,65,000.
Right. And he is ready and willing to deposit the remainder.
Already deposited.
Already deposited 43,65,000 against 82,65,000.
And the remainder of rupees.
43 reminder, my lord, it will be around 39 lakhs amount, my lord.
Today, the next paragraph. Today, the petitioner auction buyer has in the open court filed
39 lakhs.
Filed an application supported by an affidavit seeking halting of the auction scheduled to be held on
15th, my lord.
Tomorrow. Scheduled to be held tomorrow. First off, he also tells that his bank is ready and willing to remit the remainder of the auction amount, quantified in a sum of rupees 30 lakh.
39 lakhs.
39 lakh. 39 lakh. Within 3 days.
Within 3 days.
Within 3 days. First off. Learned counsel, panel counsel appearing for the bank vehemently opposed the application, contending that copy is given only now, and therefore he should be given a short accommodation to file his objections to the same.
If I may,
first off.
I may.
Yes.
I have not received the copy of the application. What I have been served with is a copy of the memo.
Application is not given.
My lord, application is there, my lord. I have prayed for stay of the impugned notice. Impugned letter, my lord.
Then is not served on him.
It's there, my lord. It's there in the I itself. But so far as the auction is concerned, my lord, I came to know it only 2 days earlier. That I filed by way of a memo. Otherwise, IA for stay is there, my lord. Your lordship would
already there.
Yes, my lord. Yes, my lord. I have filed a memo.
And one is the prayer for stay.
Stay.
And above all,
it's there now.
Memo is filed just
memo for taking up to this because stay the auction is tomorrow.
Yeah.
Request that. Learned counsel for the petitioner, auction buyer, learned counsel for the appearing for the auction buyer draws our attention to the application in IA number 1259 of 2026 filed along with the petition. First off, he has also moved a memo for additional reminding. Memo as additional reminder to the court. First off, counsel for the bank seeks a short accommodation for filing of counter objection to the said application. First off, the counsel for the petitioner submits that already his client has remitted a sum of rupees 39 lakh
43 lakh
65,000
against
as against the auction amount of bid amount of rupees 82 lakh 65,000. First one, he further tells that his client is ready and willing to remit the remainder of the amount,
39 lakh.
namely rupees 39, that is rupees 39 lakh within 3 days. First one. So telling, he seeks interdiction of the scheduled auction. First one. Learned counsel for the panel counsel appearing for the bank opposes the application, saying that the bank has no option than to forfeit the said amount, and accordingly it has forfeited. First one. Further, he tells us that the scheduled auction cannot be halted. First one, we do not agree with all this. In view of the observations of the apex court at paragraph number
117 and 118.
18 in give that case,
Yes, ma'am.
so and so, so and so. First off, forfeiture of a huge amount of rupees 43 lakh 65,000 is not a child's play. First off, there are arguable points in the matter. First off, if the auction is held, that would be doing a manifest injustice to the auction buyer, who has already made substantial payment. First off, if auction is deferred, certainly heavens will not fall down to the disadvantage of the bank. First off, in the above circumstances, the application having been favored, the scheduled auction is halted once for halted during the pendency of the writ petition. First, call this matter after 6 weeks.
Milots may not direct during the pendency of the writ petition, Milots, because they have undertaken to pay it within 3 days, Milots. They may have it, Milots, may direct it to be listed next week, Milots.
No. If no urgency, now entire amount is paid.
No, Milots, if they pay within 3
that we are giving payment of
if they don't pay within 3 weeks,
the amount,
it is, Milots, then they
we
will
have heard, kindly take you. They have to be heard. Your all points are considered. Still, you want to oppose the petition, the interim application. You should not do that. We are protecting your interest. You have already received 43 lakh 65,000. He is going to make the payment, remaining amount within 3 days, and still you want to argue the matter like this?
What I'm humbly submitting.
If it doesn't pay, you want to say.
That will make it here now.
Yes, Milots. That you
listen it first.
The petitioner shall pay the remaining amount of rupees 39 lakh within 3 days as undertaken.
Yes, madam.
Failing which the petition suffers dismissal with lock, stock and barrel.
Yes, madam.
That also.
Milots, that's all. Much obliged.
Item 23, confirm 2872 of
My lord,
2026.
in this case, last occasion, I drew your lordship's attention that we have complied with the order. We had to file a formal affidavit for compliance.
When are you filing?
That we have not yet filed. Your lordship may grant some more time because I am having the compliance instruction, my lord. Lordship had
Last occasion they have time.
No, they kindly look into whether they compliance or not. If you were to be this side, how you will view that matter?
That is not compliance.
You have not read only.
No.
And you want to argue that it is not compliance?
Because your lordship kindly see the order.
What kindly see that? Kindly see that one first. Should not be prejudged that way. A lawyer is not a mouthpiece of your client.
They have complied only so coach notice has been issued, my lord. Your lordship kindly see the page 11, your lordship. In the above circumstances, this writ appeal is disposed of, directing authority to comply with the loan and single
Letter in a time bound way. It has been prescribed in para 6 of the impugned order. Into para 6 of the order.
Thereafter, if the timeline are not complied with, then the authority shall reinstate the applications in service. And
So he is saying within the timeline it is done.
No, my lord. Your lordship kindly see 4 weeks time has been granted by the
Call
single
matter
judgment.
after 2 weeks for report.
Lordship kindly have a glance.
4 months. No, you file of it for filing compliance affidavit. Okay. Call on. Okay.
Item 24, contempt plea for.
True face contempt petition, your lordship may issue notice.
No, not the press content, my lord. Police notice has already been issued, my lord, earlier.
Third.
Yes, my lord. This is the second time.
No, I am not having that.
Yes, police notice on 24/6/20.
24/6.
My brief doesn't show this. I'm sorry, my lord. I'm so sorry, my lord. Because
we go by court order.
Yes, the officer. That is binding on us.
Who is the officer? We direct his arrest and detention.
No. Lordship may instruction I have issued. Instruction I have issued.
What was the order? Whether it is complied. What was the order of the single judge?
We seek some time for compliance, my lord. That is the instruction. Because our writ appeal has been dismissed in the meantime.
You are complying with the order?
Yes.
That part is sufficient.
Yes, my lord.
In the event you do not comply,
then
that will be aggravated contempt. 1 lakh rupees cost in addition to other things we will do.
Writ appeal has been dismissed in the meantime.
Now we have to comply with that.
Yes. And we in principle have agreed. That is my instruction.
We'll drop it with liberty to seek revival for aggravated contempt.
Yes.
This yesterday alleges non-compliance of the order dated
23/2/2026.
entered in writ appeal number.
Writ appeal number below
818. 818 of 21.
818
of 2021. First one. Police notice has been duly served on the contemners. First one. Till date, compliance report is not filed. Third one. Learned AGA Mr. Panda very fairly submits that the order in question shall be complied with in letter and spirit within
in accordance with the instruction dated 13/7/2026 issued by the director of that Board of Secondary Education.
as has been stated in the letter
dated 13/7/2026
sent by
the director of Secondary Education, Odisha, Bhubaneswar.
First one. In view of the above, the contempt proceedings are dropped for the time being, with the liberty to the complainant to seek their revival, if assurance given to this court is not adhered to, in which event it would be a case of aggravated contempt.
Other matters are arising out of the batch appeal which your lordship have disposed of. Other contents.
My lord, one, how much time your lordship granted for compliance? That we want.
It is not yet over.
No. Lordship said that it will be complied with within which period of time? That lordship 1 month.
Within 2 weeks.
Yes, ma'am.
Within 2 weeks.
3 weeks. 3 weeks. Because already that period is over.
And the 3 weeks.
Within 3 weeks. In other matters also same. All contempt matters.
Your lordship disposed of in a batch.
Where are the contempt?
Where are the contempt?
It's 3555. This is on board.
The same order.
Same order.
The sub item. He is mentioning the sub item.
Same one.
We are grateful.
Tell your officer to avoid by the court orders.
In principle, we agreed.
No, you have always said that.
No. Always said that. Paragraph 7. That is the instruction. Because we are before the writ appeal court. Our right to remedy that appeal remedy, that is also be taken into consideration. Balancing the equity, that your lordship always does.
Writ appeal is still pending?
No, therefore we are in principle we are agreeing.
Okay. Thank you.
My lord, item 3, the demand draft copy I am filing in the court.
Item 3.
Yes, my lord. 10 lakh rupees, your lordship.
You have already deposited now?
Yes, my lord. Already.
So what
Draft copy is there. Your lordship wants to adjourn the matter 7. Copy of draft I am filing in the court. The only copy, only draft we put it in the account.
The bank has received it.
Yes.
All right.
Bank has received that money.
No, he went to
You file it in the register along with memo. So that it will be part of the record.
Extremely grateful, Lord, sir.
Right.